Yes, I kind of was invited by Caroline. It's going back a couple of years now, actually, to contribute into the work that her and Yannick were doing. But also, I've done an awful lot of work with Caroline in relation to the work that I was doing in Milton Keynes as well, where...
Can you just check the connection here with you there out there in the world? Can you hear me now?
Yeah.
Can some of you say something? Because we have a problem with the loudspeaker on the set there. We have a little group here because we have two students visiting from Belgium. We're also here in the room with us who would like to hear Yannick speak.
Yeah. Can you
hear me? Say something, just see if there's...
Yes, I'm speaking. I'm speaking. Can you hear me? No?
Maria, you have your microphone turned off.
Yeah, but we were speaking. Could you not hear?
No, we don't hear anything.
Maybe we can switch to the computer audio. If you... Yeah, and maybe switch from the television to... Or there, the lowest. Yeah. The other one, maybe. But it's strange because we heard the thing.
Yeah. Can you hear us now?
Can you hear us?
Settings.
No. I'm guessing no.
There, it's low.
There we go.
The speaker is very low.
Houston, can you hear me? Come in, Houston. We have a problem.
We hear you.
Okay.
Excellent. Right.
Please
Apollo
continue.
13
Thank you.
carrying on. Yeah.
Just close my microphone there.
Right. Welcome, everybody. Yes, I think as I was just saying, I've worked with Caroline for a while she was doing a lot of work in Milton Keynes, looking at the work that we've been doing there in the youth justice system, and in particularly our work with children in primary and secondary education, where we were identifying unrecognised unmet needs of those at the greatest risk of exclusion. But the work that Caroline and Yannick have been doing, I can't take any credit for, but I am the orchestrator of linking them up with the cost action, because I think there is an awful lot of correlation and overlap between the work that's going on. And I think it's very much about trying to make these linkages between the work that is happening out there in the world and where we can make sure that we're all linking these different approaches so that we can all benefit from them at the same time. So without further ado and going into any lengthy introduction, I think I would like to invite Caroline and Yannick to introduce themselves to everybody and to move on to their webinar.
Yes, I'm going to try to share the screen. Thank you very much, and give the word to you, Caroline, but let me try to share our screen.
We can see it, but you may want... Yeah, exactly. Perfect.
Is it visible?
Yeah, that's working.
Okay, wonderful. Would you like to start, Caroline?
I'm very happy to start. Yes, hello everyone, we are delighted, Yannick and I, to be here to present our research to you. I'm, as Diz has said, I'm Caroline Lansky. I'm an associate professor at the University of Cambridge Institute of Criminology. And my work, one of my strands of work comprises youth justice, and I've been working with Yannick on this particular project, which has been looking at inequalities in youth justice decision making. Yannick, do you want to say something?
Yes, my name is Yannick van den Brink. I'm a professor of criminal law at the Vrije Universiteit Amsterdam in the Netherlands. With background in law and criminology, my work focuses mainly on youth justice, And in addition to my academic work, I serve as a deputy judge in the Youth Court of The Hague in the Netherlands, and I'm a member of Working Group 5 of the Action.
Thank you, Yannick. So Yannick and I are going to do a double act today. We're going to sort of mix and match in our presentation of the slides, and I'm going to start off and tell you a little bit about the project and also focus particularly on the role that language plays in these processes. For us, the critical role that language and communication plays in the process of youth justice decision making was illustrated vividly during our fieldwork in the Netherlands. So I was invited over to observe a trial at The Hague. This was a trial of a young man that Yannick and his judicial colleagues were adjudicating on. And I was allowed to sit in on the trial and observe and listen to the discussion. Now, my knowledge of Dutch is very basic. It draws from a smattering of my knowledge of German and Duolingo practice. And as I sat through the trial and listened to the discussion, I guess I understood about 10% of what was being said. And I wasn't entirely sure of what the outcome was. And when Yannick mentioned this to the defence lawyer of the young man, the lawyer responded and said that I had probably understood about as much as his young client had about the whole process, given his client's levels of language comprehension. And so in this little exchange, we learnt at first hand how linguistic disadvantage can severely hamper a young person's right to participate in a decision that could have adverse life-changing implications for him. So this is just one example of how we have found disadvantage can accumulate for young people in the justice system, and is going to be the focus of our discussion to you today. So just to give you an outline of what we will cover, we will first introduce our research project, its aims and methodology, and then provide an overview of some of the key principles of youth justice systems in the Netherlands and England and Wales, for those of you who are not familiar with them. We will then share our research findings and how and what they've revealed about mechanisms of inequality in youth justice decision making, and how those mechanisms of inequality can result in the accumulation of disadvantages for young people. The final part of our presentation will suggest some approaches that might help to address these inequalities. And then what we hope to do is to open up the discussion and invite you to reflect on what you've heard and some of the questions that we have thought would be interesting to discuss with you. So just to give you a little bit of background to our study, our research grew from the observation that there is an overrepresentation of disadvantaged children in many youth justice jurisdictions across the world, including in England and Wales and the Netherlands. And research evidence suggests that these disparities in youth justice decision-making play a role in overrepresentation. Yet our knowledge of how such disparities are produced or sustained is largely absent, or limited to one specific decision point in the youth justice process, say at the point of decision by the police or in the courts, rather than considering the consequences of successive youth justice decisions on a young person's life. So this work builds on a NWO Rubicon project that Yannick conducted between 2019 and 2022. And this was a project looking at inequalities in youth remand decisions, and included court observations and interviews in England and Wales and the Netherlands. And this was the project when Yannick and I first met. I was Yannick's host at the Institute of Criminology during his fieldwork in England and Wales. So our study aims to generate knowledge on how young people's early life course disadvantages, such as poverty, problematic home contexts, educational problems, lack of access to services and so on, how these disadvantages might play into youth justice decision-making processes, either directly or indirectly for interlocking systems such as the educational system or the child welfare system, for we observe that these systems often are interconnected in young people's lives. So the research that we will discuss today was an exploratory, comparative, qualitative study of youth justice decision-making in England and Wales and the Netherlands, and has been designed to act as a precursor to a larger scale study. And the research itself comprised focus group discussions, so 11 focus group discussions with lead professionals in key bodies involved in youth justice decisions in England and Wales and the Netherlands. So, for example, we spoke with police officers, youth justice and probation officers, professionals working in education, social services and child welfare, legal professionals, defence solicitors and judges. And from these focus group discussions, we developed some themes which we then explored in greater depth in 21 follow-up interviews with these professionals. So as I mentioned, our research covers sort of the impact of a wide range of childhood disadvantages, poverty, home contexts, and so on. But today we would like to invite you to look at our findings through the lens of language, and in particular to reflect on to what extent language needs contribute to the accumulation of young people's disadvantages in youth justice decision making. How language needs intersect with other disadvantages, such as poverty, education, race, gender, and so on. What are the avenues that we might consider for future research, and what routes for reforming policy and practice might there be to ensure a fairer youth justice experience and outcome for children with language needs?
Yes. Yeah, since the cost action is a multidisciplinary network, not everyone might be fully familiar with the rules and principles of youth justice. And therefore, we will now first provide a brief introduction to the key principles of youth justice from an international children's rights perspective, and to the main characteristics of the youth justice systems in the Netherlands and England. And this will hopefully help everyone to make sense of the findings of our research, which we will present later on. Well, youth justice is first of all an international children's rights issue. The almost universally ratified UN Convention on the Rights of the Child contains specific provisions that aim to regulate the administration of youth justice, Article 40, and to protect children from excessive punishment and from an overuse of deprivation of liberty, Article 37. In 2019, the UN Committee on the Rights of the Child issued a new General Comment number 24. On children's rights in the child justice system, in which it provides an elaborate commentary to Articles 40 and 37 of the CRC and outlines what a children's rights compliant youth justice system looks like. And if we look at the CRC and General Comment number 24, we can identify that a children's rights compliant youth justice system is essentially built on 4 key pillars: humane treatment, child-specific treatment, fair treatment, and treatment aimed at reintegration. First, humane treatment implies that children in the justice system should be treated with humanity and respect for their inherent dignity and worth. And this includes a prohibition of torture or other cruel, inhuman, or degrading treatment or punishment, and a prohibition of capital punishment or life imprisonment without parole. The second pillar acknowledges that children fundamentally differ from adults and should be treated accordingly. And Article 40, paragraph 3 dictates that states should establish a child-specific youth justice system, which enables responses to offending by children, which are appropriate to their age, needs, and evolving capacities. And this system should include an appropriate minimum age of criminal responsibility, which, according to the committee, should not be lower than 14. A third key pillar is fair treatment. Under the CRC, children in conflict with the law are rights holders who are entitled to a fair procedure. And Article 40, paragraph 2 explicitly grants children with a range of fair trial rights, including the right to legal assistance and access to an independent and impartial judge. Importantly, these rights are applicable at all stages of the proceedings, from the first police interview until the sentencing. Effective participation of the child throughout his or her youth justice procedure is a fundamental requirement for a fair trial. Finally, reintegration. This is the overall objective of youth justice. And this is... Oh. Someone with a microphone on, maybe? Well, the reintegration objective implies that youth justice responses to offending by children should aim to guide children towards a constructive role in society, which also implies that children do not re-offend. This reintegration objective also implies that youth justice responses should not harm children's development and should be proportionate to both the severity of the offense, but also to the circumstances of the child, and this requires tailored interventions. Against this background, the UN Committee on the Rights of the Child recommends to use diversion in the majority of cases, meaning that a case is dealt with outside the formal justice system and without resorting to formal judicial proceedings, as long as the due process principles are respected. Diversion prevents children from stigmatization and harm related to formal justice system procedures and intervention. And finally, the Convention dictates that deprivation of liberty of children, whether it's police custody, pretrial detention, or a custodial sentence, should be used only as a measure of last resort and for the shortest appropriate period of time. Where possible, non-custodial measures should be used. The Convention also includes the general principle of non-discrimination in Article 2. And this principle implies that all children, regardless of ethnicity, gender, disability, and also language needs, should have equal access to all the rights in the Convention. Importantly, equality or non-discrimination does not mean the identical treatment of all children. Instead, it relates to equal recognition and realization of rights, which calls for a tailored approach in which vulnerabilities and disadvantages of individual children are taken into account. In the context of youth justice, equality means that children are equally entitled to a proportionate response to offending to be protected against harm caused by the system response. It requires that children are equally enabled, or should be equally enabled, to exercise their fair trial rights, including the right to effective participation, and children should have equal opportunities to successfully reintegrate into society. So this was the international framework, and before we move to our findings, I will very briefly touch upon the main characteristics of the Dutch youth justice system. The youth justice system in the Netherlands is in principle applicable for children in the age of 12 up to 17, so under 18. But the Dutch system has a flexible upper age limit, which means that 16 and 17-year-olds can be sentenced as adults, which is a violation of the convention, by the way. But 18 to 23-year-olds, young adults, can be sentenced as if they are youth. The youth justice system has a pedagogical character, but it is still criminal justice. So youth justice responses are essentially founded on notions of culpability and responsibility, and children are entitled to a fair trial. The main objective of youth justice in the Netherlands is prevention of reoffending, mainly through behavior modification and reintegration, but objectives such as retribution, deterrence, and compensation for victims also play a role. Still, the youth justice system is very different from the adult criminal justice system due to its pedagogical approach, which is reflected in child-specific procedural rules, specialized institutions and professionals, and child-specific interventions and sentences. Caroline, can you say something about the English system?
Yes. So there's some interesting similarities and differences between the two youth justice systems. So the English and Welsh system starts earlier. So our minimum age of criminal responsibility is 10 years old. The upper limit is 17, as in the Netherlands. And there is a separate sentencing structure for all children under the age of 18, although recently there is a sort of a sliding scale in severity of sanctions depending on a child's age. There is less flexibility for young people to remain in the youth justice system after 17 years. Although at present, given the prisons crisis in England and Wales, there are young people who are now 18 in youth custody because they've not been moved up. As in the Netherlands, the principal aim of the system is to prevent offending. Having regard for the welfare of the child is the second core principle underpinning youth justice, which has been in effect since 1933. The system in England and Wales has adopted a number of different approaches to working with young people, pedagogical, psychological, and punitive. At present, the policy approach is oriented towards seeing the child as a child first, rather than as an offender. Although, as you might anticipate, there are inconsistencies in this approach, both in terms of policy, legislation, and also in practice.
Yes, we now come to the core of our presentation. And as a starting point, we see that, well, notwithstanding the differences between the two systems, and despite the fact that both the Netherlands and England and Wales are state parties to the Convention on the Rights of the Child, and therefore legally bound by the children's rights principles of youth justice, including the principle of equality and non-discrimination, there is evidence that suggests that unwarranted disparities occur in decisions at various stages of the youth justice process in both the Netherlands and England and Wales. And then we're talking about inequalities along the lines of ethnicity, gender, socioeconomic status, disability, and potentially language needs. For example, both in England, Wales, and the Netherlands, minority ethnic children are, under similar circumstances, more likely to be qualified as suspect, less likely to be diverted away from the formal system, more likely to be formally charged, to be detained pre-trial, and to be sentenced to custody. And what we aim to do in this project is to explore the question what mechanisms drive these inequalities in youth justice decisions across jurisdictions, and is it possible to identify system-independent mechanisms? But first, we will give two examples, more concrete examples of such evidence of unwarranted disparities. First, a study from the Netherlands that show inequalities at the front gates of the system, so to speak, namely who's formally qualified as suspect and enters the system and who's not. Official police statistics show an overrepresentation of, amongst others, youth with a migration background, low socioeconomic backgrounds, and boys as registered suspects. A study from Bezem and Leerkes reveals that this does not necessarily mean that these groups of children truly commit more offenses. These scholars have compared official police registrations of young suspects with self-reported youth crime at an individual level, and based on which they have shed light on the likelihood of being qualified as suspect by police controlled for self-reported offenses. And this likelihood turns out not to be equal. The results show that boys are 3 times more likely to be formally qualified as suspect by police compared to girls who themselves have reported to have committed similar offenses. The results also show that children who are enrolled in low-level education are even 4 to 5 times more likely to be qualified as suspect by police compared to children in high-level education who themselves reported similar offenses. Same goes for urban versus children who live in rural areas, 2.5 to 3.5 times more likely those who live in big cities. And finally, children with a migration background are 2.5 to 6 times more likely to be qualified as suspect by police compared to children without a migration background who themselves reported similar offenses. So this is truly at the front gate of the system. A second example concerns a Dutch study, in which I was also involved, on pretrial detention decisions that reveals that children with a migration background, with an intellectual disability, and children who are not enrolled in school are under similar circumstances significantly less likely to be released out of pretrial detention compared to other children. And we found a very strong correlation between the advice of the Child Protection Service, the main advisory body, and the judge's decision, implying that children with migration background with an intellectual disability and those who are not enrolled in school are significantly less likely to receive a positive advice from the Child Protection Service to be released pre-trial, which is seemingly reflected in the judge's decision. We also found that children who spend time in pretrial detention are in turn significantly more likely to be sentenced to custody. So these findings indicate that, first of all, inequalities in the output of one actor, in this case the child protection officer, might permeate decisions by other actors, such as the judge. It indicates that inequality in judicial decision, for example on pretrial detention, might permeate subsequent judicial decisions, in this case, the sentence. And finally, these findings indicated inequalities in other systems, such as education, might permeate the youth justice system. So against this backdrop, we started our research. And as the theoretical starting point of our research, we deployed the concept of cumulative disadvantage. And we used the definition of Kurlichek and Johnson to define cumulative disadvantage as a process that encompasses the cumulative impact of a specific form of disadvantage over time and or the accumulation of multiple interactive forms of disadvantage, both within and across time points. And by cumulative, we mean acquiring or increasing in force by successive additions. And by disadvantage, we mean social barriers that some children experience due to their unfavorable life circumstances, which can be poverty, disability, or maybe special language needs. And then the question, we are interested in the question, how does cumulative disadvantage shape youth justice decisions, and how do youth justice decisions in turn add to a child's or youth's cumulative disadvantage across different life domains? So using the concept of cumulative disadvantage, we want to gain insights into how social inequalities can impact and possibly accumulate in various decisions throughout the youth justice process, from the arrest up to the sentencing. We also want to explore how inequalities in youth justice decisions interact with inequalities in interlocking systems, particularly the child protection system and the education system. To do so, we are developing an analytical framework which distinguishes 7 spheres of influence on youth justice decision-making, from the micro, the intrapersonal spheres, or what happens in the mind of a decision maker, all the way up to the macro spheres, or the wider societal political sphere. These spheres of influence are closely interconnected, might be partially overlapping, and should not be viewed as separate from each other. Yet, we distinguish these spheres of influence conceptually as a framework to further our understanding of youth justice decision-making and to pinpoint how inequalities might be produced, sustained, and accumulated. And in the following slides, we will discuss and illustrate how inequalities might be produced at different spheres of influence, using quotes from interviews and focus groups. And again, the findings relate to disadvantages that might be wider than language needs, but we invite you as experts to look at the findings from your own expertise and reflect on them later on at the end of the presentation. So first, the intrapersonal sphere of youth justice decision making, which includes personal biases of decision makers. And this is an example from an interview with a youth court judge from the Netherlands. And she says, for example, when a child protection report, says the young defendant is in a drill rap group, which is associated with violence. Well, the boy says, I'm not in a drill rap group at all. He probably hangs out with boys who also like drill rap, but that doesn't mean that he really. But as soon as you, as a judge, read drill rap group, you think, ooh, dangerous. We have to put him away in detention. And that's not fair, because it's also just a neighborhood where that music is popular. I have a young family member who's very well behaved and very white, and he liked drill rap. And he had nothing to do with violence and all that, but he did listen to it. Whereas when these black boys in this neighborhood listen to that, it's immediately, ooh, drill rap. I'm convinced that that works to their disadvantage. We need to be very alert to this. A second example is also from the Dutch context. It's a focus group with prosecutors, and it's more about biases when it comes to education level. And this is a prosecutor says, well, if we're discussing a case, we try to look, can we keep the young suspect out of the formal criminal justice system by diverting the case, because we think he should be able to get a second chance without a criminal record. And very occasionally you get a child from pre-university education or high-level education. I had one who had stolen a statue from a museum, and he wanted to become a doctor or a lawyer, one of the two. I don't remember which one. But then I noticed myself thinking, because he's a pre-university student, he really needs his certificate of conduct if he wants to become a lawyer or a doctor. But our Jason, which was a fictional character from a case which we discussed, with his mild intellectual disability, might equally need his a certificate of conduct as well. And then the other prosecutor says, well, he's certainly needed because maybe he can drive trucks really well, and then you also need a certificate of conduct. But everyone in the room, the practitioners involved, were highly concerned about the impact of criminal record on the boy's future. But that boy, he's in pre-university education. And then the other prosecutor said, indeed, the class justice is huge. Caroline, you want to?
Yes. So this is an example of how personal perceptions of decision makers about youth justice, about young people's circumstances, can be shaped by their particular perceptions of their personal circumstances. So, for example, these might be framed as vulnerabilities and mitigating factors, or they might be perceived as risks. And one of the interesting distinctions that this defense lawyer draws attention to in this quote here is between perceptions of risk related to intellectual functioning and perceptions of risk related to mental illness, which they see as higher. So they say, whereas something psychiatric, such as mental illness, really ramps up the ways in which people view young people in terms of their risk.
Yeah, another example from the Dutch context, a child protection officer that was during the focus group, a discussion, and one of the child protection officers says, well, I think cooperation with parents is really important. And she talks about a case in which parents were very supportive and also very clearly said, we also find this criminal behavior unacceptable. And then she tells the others during the focus group, I see that very rarely, how special that these parents react like this, but that should be the norm. And then another participant from the focus group, another child protection officer with a different cultural background, says, well, I find it very hard to say because you talk about a norm, but I wonder what is the norm? At least in the city of the Netherlands, we're dealing with a lot of different cultures. And I know in the Surinamese culture, you go running for your child. And what I mean is, we disapprove of what happened, but I also want to go and protect my child because otherwise agencies might run away with my child's rights. And a parent often does that out of good intention, like, hey, I want to protect my child. Yeah, then we move to the second sphere, the interpersonal sphere. And this relates to interpersonal interactions between practitioners and young people. And this, I think, for this network is one of the key spheres of influence to focus on. And what we see in this sphere is that in practice, a mutual lack of trust, connection, and understanding are real issues in this context, which may fuel inequalities. Indeed, there's often a significant cultural, socioeconomic, age, and language gap between youth and youth justice practitioners. Research also suggests that mutual distrust and hostility, for example, interaction between young people and the police, may lead to misinterpretation of behavior and to escalation. We also know from research that different cultural norms may lead to miscommunication and misinterpretation of behavior, which can also lead to escalation. And in this context, the notion of capacity for impression management, developed by Chambliss, a sociologist from the US, is also relevant. And this concept relates to the extent in which, for example, a young person has the capacity to positively shape the impression that other people, for example, the youth justice practitioners, have about her or him. And here, social capital, but also specifically the language skills, can be very important. So this capacity is not equal. In this regard, prosecutors during the focus group in the Netherlands talked about the so-called likability factor. One of the prosecutors says, well, it works to your advantage if you, as a young defendant, are open and honest, take responsibility, and are able to communicate with us. Personally, I always try to make a connection with a young person, but that may very well be that because of our different backgrounds, I'm much less able to do that. And then another prosecutor says, well, some young people also don't have what I call the likability factor. I just notice sometimes I really think I don't have any connection with you, but that also generates something in me that I think I have to try extra hard because it's not his fault, but it's also complicated sometimes. And the other prosecutor said, yes, and it's also the question, how do certain young people look at us? And then another prosecutor said, well, I also realize whatever I look like, it doesn't matter. I am the system in the young person's eyes at the moment. I represent the system, and I don't quite get away from that, I think. Caroline?
Yes, so the issue of lack of trust came up in our findings too. And this quote from a police officer in England and Wales highlights a quite specific issue, which is that with lower level offences in England and Wales, if you admit guilt, then you will get either a diversion or a discharge, but you will get a lesser sanction. So this police officer identifies that for some communities, he mentions the Black minority or ethnic communities or Eastern European communities that have had a history of negative experiences with the police, either in England and Wales or in their home country, that there is already a lack of trust and a reluctance to accept the advice or the guidance from police officers. And he notes here that a disproportionate amount of what he calls BME end up going to court because they or their families are less likely to go with their advice. If they just admit it, that they've done it, they're going to have a low-level response, but they won't trust us. And he particularly draws attention to the barriers that can be added to this through a lack of language and ability to communicate on these issues.
Yeah, and another issue that came from our qualitative data was the issue of a lack of knowledge on neurodiversity needs, which may shape interactions between practitioners and young people. There was an example from a youth probation officer from the Netherlands, and she said, well, and she remembered a case in which colleagues from the youth probation service had to go to a hearing with a young person with a mild intellectual disability. And it was quite a serious offense, but he had been released on bail. So her colleagues had taken him to the courthouse. There they had to wait for 3 hours because the hearing before them was delayed, which, by the way, happens very often in practice. And she says, such a young person is obviously up against the ceiling by then. Subsequently, his own hearing also takes extremely long. There were victims present who were yelling to this boy, and the judge didn't intervene at all. Such a young person then loses it completely. They no longer understand what is happening. And at some point, he stormed out of the courtroom and banged his head against the wall. But it gives such an image to the people present there, to a judge. It is then very much about interpretation of behavior, because he is then portrayed as someone who's angry, who does not want to cooperate, while his behavior comes from somewhere. Caroline.
Yes, and the importance of language, or the challenges with language barriers, was particularly illustrated by this example that a police officer from England and Wales gave. This was of a young man from Syria who wasn't able to speak English, and so was experiencing barriers to education and also to accessing the support that he needed for what had been quite traumatic experiences back in Syria. And the police officer identifies the difficulties, the cultural barriers, but the lack of ability to communicate was a huge issue for supporting this boy. And what was also evident, he identified, was that this frustration that the boy experienced in being able to communicate was leading to increases in his levels of frustration and his sort of behavior in getting angry with his situation, which would likely exacerbate his interactions with the police and authorities later on.
Yeah, and in the Dutch part of the study, it was also brought forward that speaking a language and understanding a language are two different things and are also culturally or related to culture, at least. And this is an example from a child protection officer who talks about a boy who just came from Suriname. In Suriname, people also speak Dutch. And she says, well, most people think Surinamese people speak Dutch, but speaking Dutch and understanding Dutch are two different things, because the interpretation in Suriname is very different from the interpretation here. We Surinamese come from a we culture. Those are very different standards of interaction, and if you end up with a European Western culture, there's a lot more individualistic. What is difficult is that the conversations between the child protection officer and young people are conducted in a language that young people do not always recognize, and which can sometimes be perceived as offensive within their environment. For example, they are asked, "Didn't your mother keep you inside?" For a boy from a we culture, a mother is very important, and you should not touch that mother. The officer doesn't understand that and thinks, I don't know your mother at all, so it's not about your mother at all. It's purely the question, do you get boundaries from home? Then you, as a child protection officer, get a hostile response from that boy that you feel doesn't fit the question you ask. But the young people's interpretation is different on the question you ask because you don't ask it in his question or in his language. Yeah, a third sphere is the intra-agency sphere, which relates to, for example, caseloads, time pressures, targets within an agency, such as a child protection service agency or a court or a prosecution service, but also to a culture and diversity within an agency. And one of the judges in the Netherlands talks about that during one of the interviews. And she says, well, I think cultural differences, but also differences in socioeconomic background are relevant. It would be good if there was more diversity within the judiciary, also in socioeconomic background. Because if you have more diversity, for example, if people know what it is to grow up in poverty, then you also understand much better what it means for a child to grow up in poverty and why certain choices are much more difficult for a child. It's not just you need to hang out, you just need to hang out with the right people who are not involved in crime. Because if you don't have them living in your own neighborhood, then it's very complicated. But if you don't know that as a judge, it's a lot easier not. It's a lot easier not to become a criminal if you grow up in an affluent neighborhood than if you grow up in a disadvantaged neighborhood. That's just a fact. If you've never walked around there or don't know anyone there, it's very hard to imagine that.
And this example illustrates how the language that is used within an agency can be very alien to the young people who hear it. So this police officer gives an example of the questioning a young person about what was your intent? And the young person goes, well, I'm not answering that. And police officer says, well, you know, they don't know what intent means. And so reflects on the fact that he doesn't think all police officers use the right language with children because it's such normal language intent amongst police officers. Everybody knows what it means. So you kind of assume that children know also. And so he reflects that he doesn't think the language that is used is very child friendly and often is not able to be understood.
Yeah, the fourth sphere of influence, the interagency sphere of influence, relates to interactions between youth justice actors and agencies, which shapes youth justice decisions throughout the process. This implies that, for example, this includes information sharing between agencies, which might imply that inequalities in the output of one agency permeates decisions by other agencies. To give an example, this is from the focus group of prosecutors. One of the prosecutors says, well, the child protection agency report, yes, we pretty much rely on that. So if the report advises not to release a young person from pretrial detention, you as a prosecutor are not very likely to request for that. But then other prosecutors said, well, but sometimes the child protection agency also reports on something as subjective as are parents pedagogically equipped, for example. And then another prosecutor said, yes, that also says something about your frame of reference. And just because those parents have a culturally different parenting style than you do with your own children doesn't mean it's bad. But then a prosecutor said, but we expect the child protection agency to build that cultural bridge, but I actually don't know whether. And then the other prosecutor says, but are we being trained in this? No, not at all. So in other words, they completely rely on another agency for the information and the interpretation of the information. Another example is of this interagency sphere is that agencies very much depend also not just on the information, but also on services of other agencies, such as the availability of treatment, care homes, etc. This is also from the focus group of prosecutors in the Netherlands. And this prosecutor says, well, I've had cases where two boys committed the same offense, but one has a very warm and loving family and a mother who can take time off and look after him 24 hours a day, so to speak. But the other one's home is seriously unsafe. Then you keep him, the latter, for 2-3 months in pretrial detention until there's a suitable place for him in a youth care facility. So then one is detained for 3 months and the other is sent home after only 3 days. And that just feels, also for such a boy, that's not equality. And finally, also included in this sphere is the so-called like needs resource deficits, which can lead to cumulative disadvantage. And this is from the Child Protection Officer's focus group. And this Child Protection Officer says, well, very often children have multiple problems, and that's very difficult, both addiction, intellectual disability, or psychiatric disorders, and well, criminal behavior, for example. So the more difficult in terms of an accumulation of problems, the more difficult it is to get the right treatment and support for the child. And then another child protection officer asks, but sometimes it's indeed difficult that I do advise treatment and I know it's possible, but then there is a waiting list. It happens that a young person commit a new offense in between, and then I think maybe that could have been prevented. Would that have happened if there hadn't been a waiting list and he could have just started the treatment we all want him to have? He himself too sometimes, but if he continues to be waiting for the treatment to start, at some point he commits a new offense, and then I think, are we going to punish him for that? Caroline.
Yeah, so the fifth sphere is what we call the intra-system sphere. And this refers to the principles, laws and policies that underpin the youth justice system as a whole. So, for example, the distinction between a focus on risk or welfare and vulnerability, and how those different perceptions can shape the way in which the system treats young people. Another dimension to this sphere are the principles and laws and policies and how they might appear neutral but affect certain groups disproportionately. So, for example, we gave earlier on, and you can see how these spheres of influence interact, the role of the admission of guilt or a guilty plea, which in itself seems to be a neutral decision that will affect everybody equally. But if we take into consideration questions of language and communication barriers, questions of trust in authority, then we can see how certain groups or certain young people might not admit guilt or make a guilty plea when it would be in their best interest to do so, and as a consequence end up getting more severe sanctions. And then finally, a question about the accessibility of youth justice procedures for children and the extent to which language might inhibit access, participation rights, and so on, as my sort of very initial example of the experience of the young person at The Hague illustrates. So Yannick,
I think this is yours. Yeah.
The next sphere is what we call the intersystem sphere, which is how interlocking systems such as such as education and child welfare interact with youth justice, and how inequalities in one system might permeate other systems and vice versa. So, for example, this anecdote from a police focus group discussion in England and Wales illustrates the differences that may well play out depending on the type of school that a young person attends. And so they compare the number of times they get calls from private schools, which is very low in comparison to the number of calls they get from what they call normal state schools, which they say we might get 20, 30 or 40 a month. And so the extent to which behavior is defined negatively in a particular school, the extent to which that behavior then is reported to the police will vary. And so young people in different schools may well experience different probabilities of contact with the justice system just simply by virtue of which particular educational institution they are in.
Yes, and we see these interactions between education and the justice system also in the Netherlands, which may lead to cumulative disadvantage. There's a quote from the focus group of judges, and one of the judges says, yes, what we also notice in one of the cities that the schools are overloaded, that sometimes they also just refuse a child to commit an offense, while they have the duty of care to take children back. Now, the judge adds, schools are overloaded and don't want children who are too troublesome. Those are passed on like a hot potato.
And again, sort of thinking about intersections between different systems, this example illustrates the interaction between the care system in England and Wales and contact with the police. And again, what's being picked out here is that certain children's homes will be more likely to contact the police than others. And so for example, this police officer says the private residential facilities that are contracted out and paid for will tend to call us for every offence, because as far as they're concerned, they are a business, their employee has been assaulted or their property has been damaged by a young person, and therefore the police will be called. And so by virtue of us getting called in the first place, the young person is criminalized. So the observation is that, again, depending on where a young person is placed, and depending on the nature of that institution and the agenda of that institution, some young people are more likely to be exposed as a result of their involvement in the care system to the police than others.
Can you, Karen?
And this is also the final sphere that we have sort of identified is what we call the wider societal context. And so this refers to influences that that may play in, that are sort of more broadly established within society and that play into youth justice decision making. And so, for example, a society which already has inequality along the lines of ethnicity, gender, socioeconomic status, disability or language, those inequalities will play into the experiences and decision of young people in the justice system and the decisions of decision makers. And so, for example, racism, discrimination and social exclusion can all play out in the interactions that the police might have or justice agencies might have with certain groups. This example here is of a police officer talking about how the public may well call into the police. And this example is of phone calls from members of the public saying there's a group of Romanians that are acting really suspicious. And the police will say, well, the police call takers are trained to ask, well, how do you know they're Romanian? And the response is, oh, because of the way they're dressing. Why are they suspicious? Oh, because they're in a big group. And so again, these examples of prejudice, anxieties and fears within the bigger society may well play into public responses to the police, and the police are then duty bound to respond. In this example, the police are sort of acting as a check and balance on those calls, but that might not always be the case. And so that sort of gives you an overview of the different spheres of influence that we've identified. And now what we want to do is just to illustrate in a bit more detail the mechanisms of how inequalities might permeate in youth justice. And so we're going to just identify 4 different mechanisms that we've identified, what we call cumulative exposure, status treatment interactions, needs resource interactions, and pathway feedback mechanisms. And we are going to give some illustrations of how these mechanisms play into youth justice decision making and vice versa. So the first example is of what we call cumulative exposure. We've already identified some of these. These are the examples of where some children are more likely to have contact with criminal justice system simply by virtue of their social economic context and how that plays out in their lives. We gave the example of children in care homes or in particular schools who might be more likely to be come into contact with the police. This example here is of the reverse situation, so of children. This is a former sort of defense lawyer who talked about their own children who are in a house where they may be getting up into trouble, but certainly won't be under the surveillance of the police, in contrast to children who might be in a one-bedroom council flat who are then sort of sent outside to play and are available to be stopped and searched. She said, you don't see police in my area. You go down the road to the disadvantaged neighbourhood and you see police all over the place. The second mechanism that we've identified that can play out is what we call status treatment interactions. So this is about how a child's status, whether that's socioeconomic status or level of disability, can affect the way in which they're treated by criminal justice agencies. And so this is an example from the Children and Welfare Services focus group in England and Wales, who referred to a girl who currently had 25 live cases going to trial for assault against emergency workers. And they said that this is a girl who is severely autistic, who came from a very challenging background. The police would get reports that she had gone missing, and despite the fact that they had been told and had reports shared about the girl's difficulties, her background and her autism, the police routinely refused to treat her any differently to anybody else because they felt that was the way that she should be treated. And so they identified that her interactions with the police escalated every time and resulted in these definitions of assaults against emergency workers. Another mechanism where we have identified that inequalities might come into decision making and what we call needs resource interactions. And this again is an example of how young people may well have been identified with needs, but actually are not receiving treatment in a timely or support in a timely way. So this police officer says, we have seen the first signs of young people getting into trouble when they are 11, 12, 13 years old. We report this to the youth services, because of course, we're not social workers. We report it, but then it often takes too long before the youth services finally provide help and support. And at this age, they say, time is 3 months can seem a very long time for a young person. And if support isn't provided quickly, then a young person's problems can accumulate very quickly, and then exacerbate their sort of interactions with the police. And the final sort of mechanism that we want to sort of draw your attention to today is what are called for pathway feedback loops or path dependencies. And this is when decisions earlier on in the system then play into later decisions. And so, for example, here, the example is given of a child who may well be brought into contact with the police and be investigated for an offence. And the defence lawyer is saying the last thing they will want to do is to let the school know that the child is being investigated by the police, because they say that very often the first thing that will happen if that's mentioned to a school is that the child will be excluded from the school. And so this information that the school receives will then result in a decision that will adversely affect, in this case, the child's educational trajectory. And this is sort of called double jeopardy. So they say we don't want to double jeopardy these children. If a school knows that a child's been in a particular offence, the first thing they're going to do is exclude that child. The second example here gives, sorry.
Yeah.
So the second example here actually gives an illustration of how that pathway dependency or that pathway loop can be resisted. And so this is a court officer who says that, who sort of resists the implication or the interest of social services to ask for a boy to be remanded into custody, and this is about reflecting on the thresholds of risk and safeguarding, and she was saying that she will then argue that actually this recommendation to the courts to remand a child to be sent into custody will be resisted and challenged, and saying, why would you criminalize a child through the lens of safeguarding? So this is an example of how a court might have taken a social services concern about safeguarding and decided to remand a child into custody, but this officer is resisting that and challenging the social services judgment, which might then serve as a brake on a decision to remand a child into custody.
Yes, the final part of our talk towards solutions. Well, in this talk, we've presented an analytical framework which distinguishes spheres of influence. We talked about processes of cumulative disadvantage. And the spheres of influence that we've presented illustrate interactions between individuals, agencies, and systems. And these interactions are all implicated in the processes of producing, sustaining, or accumulating children's disadvantages. The spheres of influence on youth justice decision-making, from the micro to the macro, illuminate the multi-dimensional nature of mechanisms of cumulative disadvantage and can be used as a framework for further inquiry into how these mechanisms produce, sustain, or accumulate inequalities in youth justice decisions and beyond. The framework might also provide guidance for addressing inequalities through reforms. The framework illustrates that reform efforts should ideally be comprehensive, multi-layered, and collaborative, involving multiple professionals, agencies, and systems. At the same time, the framework also makes clear that individual practitioners truly have influence and can make a real impact. Reform can also take place from the micro to the macro. So each and every practitioner carries responsibility for actively pursuing and preventing inequality, or actively pursuing, preventing, and tackling inequality in youth justice procedures and decisions. So we will give a few final examples of promising, in our view, promising avenues for reform. And the first one is the value of lived experiences. And this was from a focus group in England and Wales. And Caroline, do you want to explain this one?
Yes. So this is about the importance of the youth justice decision makers understanding what it's like to be on the ground. So this is a child and welfare officer arguing the value of having people working in the system who themselves have had lived experience. So they actually know, the people who are sort of making the major decisions actually understand what it's like, as he says, to be down there, to get into the belly of it, to change things. So contrast that with someone upstairs looking down on a situation without really having the knowledge of what it's like on the ground. So he says you actually need people at the top to recognize the value of lived experience to drive improvements in what's happening.
Yeah, this is a second example, and we also saw this in the Dutch qualitative data, and this is a quote which from a discussion in a focus group, which I vividly remember. It was really, I think, a special moment in a 2.5-hour session with police officers, which involved one police officer with a minority ethnic background. And then at some point during the discussion went towards ethnic profiling, which is quite a sensitive issue. But one of the white police officers said, well, let's face it, ethnic profiling does happen. And then the police officer with the minority background, he says, well, guys, it's one of the reasons I became a police officer. I've been pulled over 1,000 times myself when I was younger. Whilst I've had 0 fines in my life. I often ask them why. And so the police who pulled me over, and heard many different explanations, sometimes because I had a kind of look in my eyes. I had the privilege of having a stable home. If I get pulled over again, I could talk about my feelings at home, and I was told, hey, that says nothing about you, that says something about those people who pulled you over. But if you think of someone who doesn't have that, who comes home and there's no one there, who's dealing with pent-up emotions, meanwhile already struggling in life with the basic need of being able to eat, and then also being unfairly profiled. It doesn't even have to be for that colleague and the police officer. That's interesting because he changes perspective to have had a particular intention to profile. Maybe we, police officers, were looking for a brown-skinned guy in a gray car at the time. But how do you explain that to a person who has experience of being pulled over by the police constantly? So this was one of the reasons for becoming a neighborhood cop in a disadvantaged neighborhood. And another discussion that I still vividly remember, again, kind of the special moments during long focus group sessions, was in the focus group of the judges. And it was at the end of the focus group, and we asked him, what is the key takeaway from this 2.5-hour discussion? And one of the judges says, well, look, it's obviously not a nice message that at all that you, the researchers, brought at the beginning, where you say that inequality is just there. That's visible in the data. And when I look at myself, of course, I always think, well, that's not because of me, because I am fair, etc., etc. And of course, that's tricky, that idea. So that's what I take away from this focus group session, because we've just been talking about why some families need more assistance than others. And maybe I should also say to myself, maybe I'm unnecessarily critical of some families that indeed don't quite resemble who I am or how I would like it to be, because I may be doing that with the best intentions. But if I thereby contribute to that distrust of the government and of the police and the judiciary, then I unintentionally contribute to that spiral and the disintegration of those groups. So that is, I think, what I mainly take with me from here, that therefore, unintentionally or with the best of intentions, I may be contributing to perpetuating the problem.
And then the last three examples we're going to give specifically focus on sort of questions of language and linguistic ability. And the first example is from a youth justice team leader who talks about the value of speech and language assessments. And in this example illustrates how speech and language assessment can help a decision maker to avoid having a misperception of a young person. So one of the advantages, particularly around some of the sub-elements of the speech and language assessment, he says, is that they have age equivalent scores, which is really important for a court that's looking at some hulking 17-year-old and then just thinking, oh, actually, this child's operating as a 6-year-old in some of their consequential thinking skills, which is really key. The second example is illustrative of how criminal justice agents can be sensitive in their use of language. And so this is an example of writing a behaviour contract with a young person in a language that they understand clearly what they can and can't do. And this sort of focus on making sure that the report was understandable for the young person, the police officer argued was really important in terms of just giving them the support and clarity that they needed in order to go forward. And then the final example is a sort of a broader one, really, about how the language we use and the concepts we deploy shape the way in which young people are viewed. And so this example is of the wording, the language of safeguarding, which this youth justice practitioner argues has been really important in changing the way in which young people who have been involved in drug dealing might be viewed, recognizing that actually young people can be victims of adult exploitation in sort of drug distribution networks. And by talking about safeguarding young people, that shifts the focus away from their offending to recognition of their vulnerability. So the very concepts we use, the very language that criminal justice agents employ to think about and just talk about young people who they come into contact with is critical in terms of how those young people might then be treated and what decisions are made about them. So this brings us to an end of our presentation. What we'd like to do now is stop talking, give you a chance to ask us some questions. And we've got some ideas about topics that we'd be interested to discuss with you, but also, you know, generally to get your views on what we've presented. And particularly, we are interested in your reflections on the linguistic barriers to achieving equality in youth justice decision making and how those barriers might be addressed. And we'd also be interested in your views on what should change to ensure a more equal youth justice system for children with speech, language and communication difficulties, and children whose first languages might be other than the main language of the system that they've got involved in. And then also to think about what potential avenues there are for research and policy reform across jurisdictions.
Wonderful. Thank you very much, Caroline. Thank you very much, Yannick. There's quite a shopping list to get in the next 10 minutes. I think a virtual round of applause, if we can. Not enjoying because I've got an unfair advantage in that sense. Who would like to ask a question, make an observation? Some hands coming up anywhere.
Just going to comment that your questions are the bulk of our whole action. So that's what we are
can
about.
answer them in one.
Yes.
So
Yes.
there should be lots of answers already. They should be
Right.
firing at you now, Caroline.
Yeah.
Actually, what? Oh, there we go. We've got some Alex.
Hi, thank you so much. As Maria said, yes, absolutely. This is the focus of our action. So we'll have some answers, I hope, very soon. So there was lots of slides there that I had, I'd love to find out more about. I will read your publications. Just a little bit about the diagnosis. So in the England and Wales, who gets the diagnosis? We know that many language difficulties are undiagnosed, but you did mention some. There was some mild intellectual disability or neurodiversity. So where does the information come from? Is this from schools? So the school statements are shared, or is it in the care homes that are there? Yes, something more about that I'd be interested to hear about. Thank you.
I'm happy to talk about England and Wales, although I actually think Diz might be quite a useful person to speak on this topic.
I was going to say, I mean, that's I am going to jump in here a bit because I think the issue around diagnosis or non-diagnosis is a key point at the moment. I'm aware that the Ministry of Justice are currently looking at potentially revising the way that youth justice teams record whether a child has a need, not necessarily based on whether they've got a diagnosed need, but actually on some informal assessments as well, which is on one hand is a positive step forward, and on the other hand, I think actually could be a huge disadvantage if it's not actually accepted across all of the different agencies. So whatever the criteria is, whether it's a formal diagnosis or an informal diagnosis, I think the key bit for me is that actually everybody is accepting it, because if not, what we'll do is create greater fragmentation and a greater sort of level of postcode lottery amongst the way that children are dealt with within the system. And then coming back to your how easily accessible is that information, how well is it passed over? I think that depends very much on how those different services work together. So in the same way as both Yannick and Caroline have highlighted some of the issues that impact all the way through with difficulties being compounded, then you also can have, if you like, the replicated opposite effect of that, as if you get a system that's working effectively, then those will be almost like the best practice models where that information is being passed across, where those level of disadvantages are highlighted, are explicitly discussed, are raised up. But I would say in the majority of cases, it is that fragmentation. It is that almost snowballing impact of difficulties becoming bigger and bigger and bigger as they go from system to system to system. And one of the points I think that you made, Yannick, that I thought was a really useful one, was the idea of the lack of training, the lack of understanding in the receiving service is such that the information comes across, and even though the information may be potentially neutral, the interpretation of that information is accepted wholesale. So it depends on who is giving the information and what their particular value system is as to how that information then becomes interpreted. And again, that becomes a complicating, making it even more significant in terms of the way that it impacts on it going forward. Caroline, do you want to say anything further on that?
No, I mean, the only other observation is that in schools, there is some assessment that takes place in schools. Again, that's variable. And, often, and Diz, I think you'll probably support this, certain children will be identified and put forward for assessment ahead of others. And that, in fact, we research that Diz and I have been looking at have identified that sometimes girls tend to go under the system more than boys, which is an interesting sort of observation from some work we've been doing.
Yeah, thank you. Jeanette?
Thank you very much, Caroline and Yannick. That was really impressive and so many great examples. And I love this type of qualitative research because you get glimpses of different groups that have to do with this child justice system. And like Alex and Maria said, this is one of the big goals of our cost action, to get answers to the questions that you raised at the end. So we don't have any real answers yet, but I think we're starting to get on track with the beginning of answers. And I feel that, raising awareness about what, from a linguistic point of view, we see as contributors to speech, language, and communication needs would be a very important first step. And so things that you mentioned, like, intellectual disability, school dropout, low socioeconomic status, these are also contributors to speech, language, and communication needs, besides having a real language disorder or having autism with a comorbid language disorder, for example. So I think it's very important that people who are actors in the justice system are made aware of this, and we know that a lot of them are not aware. So, I mean, the people that came to your focus groups are interested already, but they also show that they perceive the information, that reflect. So I feel that there is hope. So if we can reach those people again with newly accumulated knowledge about what contributes to language needs, that would be a great first step. So, you really prepared the grounds for this. So thank you.
Yeah, but also the other way around with this intervention, Jeanette, thank you for your kind words, but also for because this is, I think, about awareness. Before participating in this cost action, I wasn't that aware of language, and especially what you mentioned about intersections with ethnicity, but also socioeconomic status and disabilities. And I think that also helps us make sense of what we find in our project, and also can use this to report back in publications or in trainings of practitioners. So I think this is shows the value of this network. I've never talked to a linguistic scholar before entering this network, so this is great. Yeah.
And now we're both in Amsterdam. So.
Yeah.
Good. Thank
Maria.
you.
Yes, so thank you very much, Caroline and Yannick. The intention of this was precisely to show what there is already, all the research that pre-existed, as we said, to see how now everything we are developing can fit in and contribute. And one peculiar accent of our group is that we are linguists, as you know, and we are steering away and wanting to clarify what in this accumulation of disadvantages and conglomerate of problems, where exactly language sits and how it can be best identified and made better. So how intervention can be actually be targeting and getting into the language per se, which is the novelty of this group, and how we insist in what is language exactly and what I mean. So yes, communication, but we are putting the accent on language per se. And we really look forward to talking more when we have more results. They are coming along, but we will get there. Now, the question I had is that in your presentation, you've spoken a lot. I mean, in your data, the biases that permeate the sectors that deal with these children seem quite high. Right, so they speak about their own biases, their own preconceptions. Is there, were you aware, or is that documented in your research, any training towards those biases, the cultural biases, the general behavior biases? Anything about that?
Caroline, you want to go first?
Yeah, I think that's a really interesting question. I mean, so there absolutely is training on sort of on bias, on sort of unconscious bias, and so on. So these programs exist, and I think and certainly so there are two things. One is some people are particularly sensitive and aware of these issues, and I think I mean, certainly within some of the services, we identify that there may be children who are working, there may be professionals working specifically with children, disadvantaged children, and they are the ones who will be, as probably many in our research, they're the ones who are sensitive to these issues and engaging with these issues. But there are also people who may not have had access to the training, or may have done the training a long time ago, or may, and I think that sometimes also the pressures of work, the time pressures that people are under, the sort of the volume and pace of work mean that some of these resourcing issues are just not followed up as much as they might be. Yes, Yannick, I don't know if you want to.
Yeah, I think in the Netherlands we are, I think, even running behind when it comes to this compared to England. Actually, one of the reasons for doing research in England was that, at least on paper, in policies, there is more in place, at least back then, than compared to the Netherlands. So I remember also when doing the research in the English courts that I believe unconscious bias training was mandatory, in the Netherlands, judges can follow courses on like inequality or bias, but I think it's not mandatory. So then you only have the people who are already interested in it, and we probably already are more aware of it, following these courses. So no, I don't think that's very well safeguarded or a such system.
I was just going to add a bit. I'm aware it's not my research or my presentation, but I think it's relevant. And I think it's the impact of budgets that when you're looking at the systemic model, it's the impact of budgets, because when budgets start to shrink, thresholds start to increase, and that's when you start to get these perverse incentives. So, for instance, there was some good examples in there where you would think it's bizarre that you're having social workers or those from social work backgrounds advocating for children to be kept in custody. Unfortunately, I've had that experience too many times through my professional career, because of course their cost of keeping a child in an expensive care placement is much cheaper than if that child gets remanded into a custodial placement. So that has an impact on people's professional judgments. It shouldn't, but it does. And I think we need to look at this in a real world, not in an ideal world. And I think that is part of the compounding issues that we're dealing with. I'm going to come to your question in just a moment, Cecile. I just want to mention it before I forget. The Michael Seif Foundation yesterday published a report called Justice for Children with SEND and Neurodivergence. I haven't yet had the chance to read it, but I've seen it. It's now available on the internet, so you should be able to locate it. For some bizarre reason, I can't find it on their website, but it's covering an awful lot of the same areas that we're currently looking at within this and within costs. So I think that there could well be some relevant information there that is worth us all accessing and feeding in. Cecile, your question.
Before you move on, sorry, would you mind sending it to either me or Hannah by email, so that we'll distribute it?
I'll do that now. I'll
Thanks.
send it to Hannah and
Thanks.
you both now. So, you're on mute, I think. No, can't hear you.
Ask the question via the chat, maybe.
Unmute. Let's see if I can. Where is this? Yeah, you are unmuted. I don't know why it's not working. Okay.
No, we can't.
It's very, very low. Something, but very low.
No. Do you want to ask a question via the chat?
Oh. Chat. 1 second. There we go. That's it. Oh yeah, I just wanted to emphasize the challenge of communicating across sectors. Struck by your mention of age-related interpretation of the language assessment, 17-year-old functioning as a 6-year-old need guidelines on how to interpret the language evaluation. Well, I can, yeah, absolutely. I completely agree with that. And I'll allow Caroline and Yannick to come back. I will jump in on that one because I know that was my example in terms of the feeding in. I spotted that one, and that was from using some of the age assessment that you can use within CAL 5. So some of the subtests have specific age equivalent scores that you can use. I'm aware from a professional's perspective and for speech and language therapists that they're less comfortable in terms of doing this on a regular basis. But sometimes within the context of a court, when you're trying to get a message across 2 sentences, using some of those rough and ready versions can actually get a far greater level of insight to your target audience at that point, and that enables the discussion to start, so you can actually begin to do that level of learning to give them that level of enlightenment about what they're really dealing with.
Yeah, I'm that judge that needs this, probably.
But yeah, no, but absolutely. And one of the things that has been identified in where inequalities can slip into court decisions is that absence of information. So even a rough guide can be a guideline which can then shape a decision. But without any information, then you know, there is often the sort of the default assumption about what a young person might represent.
Thank you.
Any other questions? Anybody else? I'm aware that I don't know how we're doing for time. I think we've
exhausted it, I think.
Well, in that case, can I just say thank you very much to Yannick and to Caroline. I'm really pleased that you managed to do this presentation. I'm very pleased that we've managed to link you into cost as well, because I think, again, where the shared aims and direction that we're all going in is the more of us in the room or in the virtual room, so to speak, is really important in traveling in the same direction and making that huge difference. So thank you very much. Another virtual round of
Round of
applause.
applause.
Thank you.
Thank you very
Thank
much
you.
for your time,
Thank you.
Caroline and Yannick.
Thank you both.
for
you.
inviting
Talk
us.
more soon.
Thank you.